A very warm welcome to this, the ninth lesson of our series on the law of evidence. In today's lesson, we will discuss the meanings of two terms that find themselves mentioned in Section 3 of the Indian Evidence Act. We will talk about fact and fact in issue. In the previous video, we had spoken about the distinction between fact and law without getting into the definition of fact, right? So again, if I were to just summarize as to what we discussed in the previous video, a fact is basically something which is placed before the court and a person testifies about it, either in the form of a witness or through a document. So anything which is the subject matter of testimony is a fact. On the other hand, the law is something which is the law of the land, and of course the court believes that to exist, so it is the law which the courts take cognizance of. So we know the difference between a law and a fact. In this video, we will look at fact in some detail. So Section 3 of the Act, which is the interpretation section, also gives us the meaning of fact, right? So you can see that fact means and includes. You have these 2 points here. Just take a moment, pause the video and try to make some sense of it before you move any further. So I will be going ahead, but make sure you pause the video once. So it's fairly obvious that the definition of fact in Section 3 contemplates two kinds of facts. The first, anything, state of things, relation of things capable of being perceived by the senses. Second, any mental condition of which a person is conscious. Now, before I delve into the meaning of these, I want you to pay attention to the structure. Now, this is something that you will be able to use not just for comprehending this section, but for comprehending provisions in general, whether in the Evidence Act or outside of it. So you see, whenever you see something which says that something includes, and then it goes ahead and say gives you 3 subpoints, okay? Let us say the first subpoint, obviously it contains some data, so it goes like something is contained here, okay? Now, whatever is contained in the second one, regardless of what that is, one thing you can know is that it does not contain what is given in the first. Very important point. The second will not repeat what is given in the first. That's why it's a second entry. It means it does something new. There will be no overlap. Likewise, whatever is given in the third here will be something which is not given in the first and second. That's why it's there in the third as an independent entry. Now, how do I apply this here? Well, there are a couple of things I can draw from this. I'll just perhaps talk of one of those. See, one of the things is that you can see in the first one here, it talks about something being capable of being perceived by the senses, right? Which means that this condition does not apply here. Perhaps it could be something, rather, it does include things which are not capable of being perceived by the senses. So I just want you to stay alert to this fact that when you see a subsection 1 and a subsection 2, you must understand that subsection 2 gives you something new, something which has not been given in the first subsection, right? Let's go a little further and analyze these two subparts a bit more. So the title given to the first kind of facts is that of physical facts, right? So we call them physical facts because those can be perceived externally by means of the senses. Now, what are the senses? You have 5 senses, the 5 sense organs. I hope you know what they are, right? I don't want to go and repeat what the 5 senses are, but okay, let me say it. So you have sight, you have audition, that means the ears, you have taste, and you have touch, and what else? Smell. So you have these 5 senses, right? So something which can be perceived by these senses is the first kind of fact, which is the physical facts. The second kind of facts is a mental condition, which are the internal things that are not manifest, that you cannot see from the outside, that you cannot assess by the exercise of these 5 senses, okay? Let's look at a few examples. But before that, I want to ask you a little question. If you look at what we just saw about what a fact is, if you look at the first subsection, the first word there is that a fact means and includes anything. Let's think about it. If anything is a fact, then what on earth is not a fact? If anything is a fact, then what is not a fact? Well, here's your answer. Facts or events that have never happened nor that are happening presently, but are only expected or anticipated events, are not facts within the definition of section 3. So when you talk of facts or anything which are capable of being perceived by the senses, it only refers to such things, state of things or relation of things, which have either been a matter of the past or are happening presently. It does not include what is expected to happen in the future, right? This of course was said by the court, so I've given you the citation as well. Now let's go ahead and have a look at a few examples of what kind of facts we have. We look at the illustrations to the section which give us the most authentic examples. So when we look at the illustrations that are given in section 3 after the definition of the fact, let's have a look at them one by one. The first illustration, illustration A. It says that there are certain objects arranged in a certain order in a certain place. This is a fact. Let's think of it like this. You see, arranged, there are certain objects. These are things, right? Arranged in a certain order. Well, arranged in a certain order is perhaps a state of things. And when they are arranged in a certain order, they might also have a certain relation, right? A relation of things capable of being perceived by the senses. Which sense do you think is being recruited in perceiving this? So you see, there are some objects, let us say there are 4 books. Books have been arranged in a certain way or one on top of the other. Now how do you perceive this? Are you using a sense to perceive it? Yes, maybe the most obvious for us is perhaps eyesight. Maybe you could use touch, perhaps not smell, but you get the idea. It can be perceived by the senses. So perhaps you can use sight, and then you know that there's a certain set of objects that has been arranged in a certain way, and therefore this is a fact. What kind of fact is it? It falls within the first subset, within the first subclause, right? It's a physical fact because you can perceive it by the senses. Let's look at the next illustration. That a man heard or saw something. Now you see, something is a thing, right? And if he saw it or heard it, it means he used one of his 5 senses. So it's a fact. Fairly clear? Again, this is a physical fact, the first category, right? Let's look at the next illustration. That a man said certain words is a fact, right? So when he says it, again, it's physical. It can be, you can feel it, you can hear it. It is in that sense capable of being perceived by the senses, and those certain words are also a thing. Everything is a thing. So as you can see, all of these are matters of the past or the present, right? So the words were said, it's a matter of the past. Could you perceive it by the senses? Yes. So these are the illustrations in section 3 which correspond to facts. So you had 2 types, the physical ones and the second one that we called the psychological ones. So these 3 are the physical facts, right? And now we look at the remaining illustrations to this section. That a man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular situation or a particular sensation is a fact. Now, how do you perceive whether a person has a certain opinion or in what sense he has used a certain word, right? Some words can have different meanings. You can use them in different ways. Can you perceive it by your sense of smell, by your sense of sight, audition, taste, touch? No, you can't, right? So it's not something that is capable of being perceived by the senses. But it is a mental condition of which a person is conscious, and therefore it is a fact. What kind of fact? It is a psychological fact, right? So you know it's a psychological fact. Likewise, that a man has a certain reputation. A reputation again is a psychological fact. So I think it's fairly clear as to what a fact is. We've already seen that the fact is something which is not necessarily the truth, right? And you can see that the definition of fact is quite wide. It includes almost everything. So you know what a fact is. It doesn't include things of the future. So I think we're fairly clear with what a fact is. Alright, so section 3, the interpretation clause, also defines what a fact and issue is. We've briefly discussed this earlier, but not in its statutory definition. So let's look at this now. I'd recommend that you pause the video once and try making some meaning of it by yourself first before listening to what I have to say. So you can just go ahead and pause the video first. So I assume you did, and now I'll talk. So the expression facts and issue means and includes, okay, any fact from which, either by itself or in connection with other facts, okay, the existence or non-existence, okay, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. Now, what do we mean by this? Okay, it says that fact in issue is basically a fact, right? A fact in issue is a kind of fact. So we just saw what a fact is. A fact from which the existence, non-existence, nature or extent of any right, liability or disability necessarily follows. Now you might wonder as to what a right, liability and disability is. Let me give you a few examples. Let me first give you an example of a right. Do you have a right to say free legal aid? Yes, you do. In a criminal trial, you have a right to free legal aid. Tell me in the comment section as to what that provision is. Search for it. So you have a right to free legal aid. It's your right. Okay, so we know what a right is. Do you know what a liability is? Let me give you an example of a liability. Suppose you are guilty of somebody's murder. You're found guilty of murder. Then you have a liability. The liability being that you get a minimum sentence of life imprisonment if you're found to be guilty of murder. So that's a liability, right? Let me give you an example of a disability. Now, a disability is a legal disability. Let me give you an example. Let us say you must have seen that when you perhaps sometimes apply for a certain job or an exam, it asks you, have you ever been convicted for an offense or whatever? And if you say yes, then you are disqualified from doing that. So that is a legal disability, right? So we know what a disability is, what a right is, and what a liability is. So any fact, whether by itself or in conjunction, read in conjunction with other facts, which leads to the determination of the existence, non-existence, nature or extent of any right, liability or disability, it is a fact and issue, right? Putting it a little differently, a fact and issue is a fact out of which some right, liability or disability necessarily follows, which means that once you see one such fact, that means once you see a fact and issue, you'd know something about his right, liability or disability. You'd know whether it exists or does not exist, which means is the right there or not there. You'd know if it's there, what is the nature of the right or how much of it is there. So the existence, non-existence, nature and extent you come to know by seeing a fact and issue. Let me give you a very simple example. Let us say A is being tried for the murder of B. My favorite example, A being tried for the murder of B. If I give you a certain fact, the fact is that A is 2 years old. Is this a fact in issue? Take a moment to think about it. What is the test? From this fact, by seeing this fact that A is 2 years old, is there any kind of existence or non-existence of any right, liability or disability that you can conclude from that? Yes, you can conclude something about his liability. If a 2-year-old commits what is by definition murder, well, he has no punishment, which means it talks about the non-existence of liability. Therefore, the fact that A is 2 years of age is a fact in issue. You get it? Because it tells you something about the non-existence of a liability. Similarly, let me give you another example. We spoke of free legal aid, right? So let us say again that A is accused of the murder of B. Now let us say A is a pauper. Let us say I give you a fact that A is a pauper. A pauper is somebody who's indigent, who doesn't have money. Does this give him any kind of right, liability, disability? Does it give him, not give him? You know it? So when A is a pauper, which means that he's indigent, then he gets the right to have a representative, a legal representative from the government free of cost. So you see, it gives him a right. So you see, even this is a fact and issue. So you see, any fact which allows you to conclude or derive any kind of right, liability or disability from that is a fact and issue. Let's look at a few examples that are given as illustrations to this section. So let us look at the illustrations one by one. Again, the section uses the same old example of A being accused of the murder of B. In the illustrations, you will now see which facts in the trial may be facts and issues. So let's look at them one by one. The first, that A caused B's death. How is this a fact and issue? Think about it. That A caused B's death. Does this talk about the existence, non-existence, nature or extent of any right, liability or disability? Indeed. Let us say either A caused B's death or he did not cause B's death. Does this affect his right, liability, disability? Yes, it affects his liability. In case he has caused B's death, then he becomes liable, which means it talks about the existence of his liability. And suppose he's not caused the death, then it talks about the non-existence of his liability. Therefore, it's a fact and issue. I hope you get this. Let's go on to our next sentence. The next illustration, which has been given here as a fact and issue. That A intended to cause B's death. How is this a fact and issue? Think about it. A person intended to cause B's death. You see, if intention is there, if mens rea is there, you see, that's an essential ingredient of the offense. If there is mens rea, then you are guilty. If you are guilty, then you are liable. If you do not have mens rea, then you are not guilty, and in that case you are not liable. So again, this determines the extent, the existence or the non-existence of his liability. Second, if he did not intend but had the knowledge, then it's a lesser offense. So then it would talk about the extent. I hope you get the difference. Let us say there are two cases, and I want you to pay a little attention here so that you get the point. There are two possibilities, that A intended, then that A did not intend. Okay. If A intended, then he is liable. A did not intend, not liable. So here it talks about the existence and here about the non-existence. This is clear. So in this case here, this is about existence, here this is about non-existence. But there is one more possibility. He did not intend, but perhaps he had knowledge. Isn't that possible, that he had knowledge? In that case, it is not a very grave offense. Maybe it might be culpable homicide, which is punishable under 304 second part, right? Which means he might not be punished as much, but he will be punished, which means it's less liability. So the less liability implies that it's talking about the extent of his punishment, the extent of his liability. So you see, existence, non-existence, and the extent of his liability. Also, we come to know what the nature is, right? What is the nature of his liability? The nature of his liability is punishment. So I hope you get the point. Let's look at our next illustration and see how it is a fact and issue. That A had received grave and sudden provocation from B. How is this a fact and issue? In fact, let me leave this to you. I'll not explain this. Let me know in the comment section as to how this is a fact and issue. Then, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind, incapable of knowing its nature. Well, this is fairly clear. It's like the example that I told you of a 2-year-old boy. A 2-year-old boy, like a man of unsound mind, does not have mens rea. More importantly, section 84, right? When a person is of unsound mind of the Indian Penal Code, the general exception, section 84, says that a person who is of unsound mind, what he does is not an offense. So nothing is an offense if done by a person who at the time of doing it is of unsound mind. So this determines the non-existence of his liability, and hence it is a fact in issue. So until now we've understood that facts in issue are those facts which the court would necessarily have to decide upon, right? Because it is from these facts that the rights and liabilities of the parties are determined. Simple. Also, is it not fairly obvious that the facts in issue would be disputed? Because if they were not disputed, then you wouldn't even be considering the evidence for that. So you can kind of think of the facts in issue as those disputed facts on which the court has to decide on the basis of evidence, because it is from these facts that the rights and liabilities of the parties are determined. Now, how was this done in the criminal process and in the civil process? Let's just have a brief look at this. You see, in the criminal process, this is done by means of the charge, right? So for example, let's take the sessions trial. In the sessions trial, you know that there comes a point at section 228 of the CRPC when the charges have to be framed, right? Now, what is the charge? You can look at chapter 17. It will tell you what the contents of the charge is, right? And then you realize that the charge basically tells you as to what the main matter is, right? So you know that in the criminal process, the framing of the charges is where the facts in issue are identified. In the civil process, you have the same thing. It is the framing of issues, and you find this in order 14, right? So you find out as to what the material facts are, the facts which are in dispute, and thereafter the facts in issue are decided, and the court decides upon them and finally arrives at the judgment. So to conclude, let's look at facts in issue in the most simple manner. Facts in issue are the disputed facts on which the court must pronounce its decision, right? And since we've simplified it, let us also complicate it, because that's also what we do by giving you the Latin name for facts in issue. So factum probandum, right, is the Latin word for facts in issue, which means the main principal facts that have to be proved. The principal facts that have to be proved. Principal facts that have to be proved. So you can also think of facts in issue as the main facts that have to be proved because they are in dispute. I hope this lesson made some sense to you, and thank you for your patience. Good day.